So let's get into machine gun news on this episode of John Crump News. What's up, guys? Welcome back. My name is John Crump, and I report on 2A issues such as what I am reporting on today. Let me just adjust my camera a little bit here. And today we are reporting on machine guns. The case that we're discussing went up to the Sixth Circuit Court of Appeals. It is the United States versus Bridges. So let's go ahead and get up to date what happened here. Okay. So let me just turn that off. Sorry about that. Joaquin Bridges was busted for having an unregistered machine gun, and he was charged in the Western District of Tennessee, specifically in Memphis, for having an unregistered machine gun. In order to have a machine gun in the United States, it has to be made after 1986, thanks to the Hughes Amendment, which was a compromise by some so called pro gun people in the Firearms Owners for Protection Act of 1986. So, how can something be banned, protected, and banned? We're going to get into that. So, he argued that because of Bruen, that the banning of machine guns cannot happen. So, in order to have a machine gun, it has to be pre 1986, pre May 1986, and you have to do a bunch of paperwork, pay a lot of money because they're drying up, and register with ATF, go through background checks, mug shots, fingerprinting, all that good stuff. He did not do that. He just owned a machine gun, and it was found by the police. So he was convicted of having a machine gun. He appealed, stating that the law banning machine guns violates the Bruen decision of the Supreme Court. The Bruen decision of the Supreme Court, I'm sure all of you are familiar of, but it said in order for a law to be constitutional, it has to be consistent with the original text, history, and tradition of the Second Amendment. So he appealed and he lost in district court, went up to the Court of Appeals for the Sixth Circuit, and it was argued in front of a three-judge panel. The three-judge panel looked at the situation and they said, let's look at if machine guns are protected by the Second Amendment. They looked at what machine guns are and they're bearable arms. So therefore, they are protected by the Second Amendment. And Mr. Bridges, Joaquin Bridges, is a member of the people. The people refer to the political class, basically anyone over 18. Uh, you can't see. Can other people see me? Because I think other people can see me. So I don't know why you can't or hear or see anything. Okay. So, okay. So what happened was they said that machine guns are protected arms because they are bearable arms. And Mr. Joaquim is a member of the political class, which means age of majority, 18 in the United States. Therefore, they said that machine guns are protected by the Second Amendment, but they can be banned. You might be wondering why they can be banned. The case does reference Miller. Miller was a 19 like in the early 1900s case right after the NFA passed, dealing with the transportation of short barrel shotguns and rifles, and they said that they could be banned because they are not really have any type of military use. Then they went to Heller, and Heller has something in there that says dangerous and unusual. So we know that it's protected class, but Sixth Circuit, the three-judge panel said that it's dangerous and unusual to own a machine gun. The way they came to this conclusion is that machine guns are inherently dangerous because when you pull the trigger, it goes bang. Of course, any gun goes bang. So therefore, it satisfied the standard of dangerous. Now let's talk about unusual. The defense here put up a statistic saying that there's 750,000 machine guns registered in the United States in public use. The court disagreed with that. The court said by their research, they can only find 127,000 machine guns registered. They said that most likely the defense was quoting guns in the hands of police, like SWAT teams specifically, and that police do have machine guns, but those cannot be used to determine in common use. So they said around there's only 127,000 machine guns in the United States in private hands. I don't think that is correct, but I guess I got to do more research on that because my research says 750,000, but they went with 127,000. They said that 127,000 does not represent common use because they said that that is only a small fraction of the 350 million guns or more in the United States, and 127,000 is only a small fraction of that number. Since they are dangerous and unusual, that the government can ban them because of the Heller ruling, which said that you can ban dangerous and unusual weapons. The gun that was in question here was a post 1986 machine gun. And yeah, Mr. Bridges' attorneys tried to argue that if a gun is in a safe, that it's not dangerous because it's just sitting in a safe and cannot fire unless it's at 320. That's a joke. So yeah. So therefore, it's not dangerous. The court rejected that as well. Now, this was a three-judge panel that ruled on this, and they could do what is called an en banc hearing. And I'm sure Mr. Bridges' attorneys are going to ask for an en banc hearing. An en banc hearing means that the full bench will hear the case. Unlike the Ninth Circuit in California that we discussed earlier today, if you haven't checked out the video, go check out the video. The Sixth Circuit only has 16 judges, so this would truly be a en banc. The full bench will hear it. Now, will the Sixth Circuit take the case? They don't have to. An en banc hearing is not a right. You can request an en banc hearing, and it's your right to request an en banc hearing, but the Sixth Circuit can reject that. Now, if the Sixth Circuit takes it up, we start over. The three-judge panel decision is vacated, and it's like it never happened. If the Sixth Circuit rejects it, Mr. Bridges and his attorneys can appeal to the Supreme Court. The Supreme Court can then take the case and decide whether machine guns are in common use or they're not in common use. They can decide whether the government can ban post 1986 machine guns or they cannot ban post 1986 machine guns. We'll have to wait and see. But the first thing that we need to do is wait and see if Mr. Bridges' attorneys, and he's represented by public defenders, whether they file for an en banc or not. Hopefully they do, or they decide just to go directly to the Supreme Court because they don't have to ask for an en banc, they can go directly to the Supreme Court. I'm not sure which way that they're going to go, but I'm sure that they're going to do one of the two, or they should do one of the two. His attorney was Greg uh, Gookin from the Public Defender's Office in Memphis, Tennessee. So we're going to have to see what happens with this case, but it is definitely interesting that they said that machine guns are and are protected by the Second Amendment, but they can be banned because they're not in common use. So they said one good thing and one very, very bad thing. So we're going to see what happens next with this, but we should just get rid of the NFA totally. And you should be able to get a machine gun shipped directly to your door. You should be able to prime that shit off Amazon. But that is just me. So that is it. And that's it for today. Any other questions? Any questions before we go? Alabama, live life. What is up, buddy? All right. I'm going to wrap it up here and get going. Um, and I will see you guys tomorrow or later on today, depending on if anything breaks. All right. Thank you. Bye.